My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there is nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door. Pam! Welcome everyone to another exciting edition of the Immigration Survivor Show, day 25 of the 30-day marathon edition with Dr. Ope Banwo and his 4 musketeers. But I've got the 2 musketeers with me tonight. Grace Okafor, who handles a lot of our research and a lot of our follow-up with clients. Thank you so much for doing what you do. And of course, we have Samuel here. Samuel
Thank you,
also,
sir.
our senior paralegal. Yes, I know your own is always like, your audio is like 10 minutes after. But it's the collection. I get you. Grace, good to have you. And Samuel, thank you for what you do in helping us to put everything together, making sure I don't forget my lines, make sure I don't forget what I need to say. Thank you, guys, and for the rest of the team behind the scenes tonight. Jolomi who's out there, and of course, Mr. Steven. Also, thank you all for making this show a great one, and I want to appreciate you as I put you in the back studio to continue to help me coordinate those questions as they put it on the screen. Tonight, guys, is going to be an exciting one. And of course, just in case this is your first time of tuning into this show, my name is Ope Banwo, and they call me the Immigration Rottweiler. And whether you are joining us here in the US or from anywhere around the world, I want to thank you for spending part of your day with us. This is day 25 of our 30-day Immigrant Survivor Marathon. And this is a public service a series that we're using to celebrate our new office in Dallas Arlington office, Banwo Law in Dallas Arlington. Okay, I don't know, all those cities are jumping into each other, but we are in the Arlington part of Dallas, as they say, after proudly serving immigrants from our Nebraska office for over 30 years. Yes, we're in Nebraska 30 years, and now we're in Texas. And our mission remains the same in all our offices as we go national to help immigrants achieve the American dream without the immigration nightmares. Every day, as we all know, thousands make decisions that will affect their future in America. Some of those decisions bring them closer to their dreams. Others, often because of bad advice, misinformation, or simple ignorance of the law, can put everything they have worked for at risk. And I see this every day. And that's why we're here. Not to create fear. I'm not the prophet of doom. Not to promote politics. Politics has no place in what I do as an immigration lawyer, but to replace confusion with clarity, fear with preparation, and replace rumors with real immigration knowledge. So tonight is another important show because we'll be discussing one of the most misunderstood immigration laws in America today, and one that every immigrant should understand, regardless of your current immigration status. We're going to be talking about that, right? And then you don't want to miss that one tonight. And it don't matter whether you're an American citizen already, or you're still trying to get your papers, or you have a green card. You want to hear my memo today. You may be innocent, but you may still lose your American dream. That's what it's about. And it's of interest to everybody. Of course, after the memo, we'll bring you the Banwo immigration brief, or call it the Rottweiler immigration brief, where I'm going to be breaking down today's biggest immigration developments in the update, including two major U.S. Supreme Court decisions that could affect asylum seekers that came out today. There's also something on TPS from the Supreme Court came out today. And of course, we also talk about some of the developments in future immigration policy. We're going to be talking about that in the Rottweiler immigration update side. And as always, we're going to end up the show with my favorite segment, your live immigration questions, where we're going to be providing questions and answers to your questions wherever you may be in the world. Because chances are, if you have a question, thousands of other immigrants also have the same one. So we're going to try our best to answer those questions tonight. So grab a pen, grab a notebook, invite your family to watch here with you. And if you haven't done so already, please subscribe to the channel on YouTube. We are live on YouTube right now. We are live on Facebook. We are live on LinkedIn, and we are live on Twitter, I think. So wherever you may be watching this, please help us share the link with your friends. Subscribe to our channel. Share this broadcast with someone who needs reliable immigration information. Because what I always say is this: knowledge is survival, preparation is protection, and ignorance has never won any immigration case. So we're going to start tonight with the Immigration Rottweiler's memo of the day. And I told you before, this is going to be a doozy. Here is my memo for tonight. Remember, it is more, my show is not just about answering questions, it's also about educating the public, helping you to deal with some of these tough things that is happening in immigration law in America. And I say you may be innocent, but you may still lose your American dream. 5 lessons every immigrant must learn from the Laken Riley Act. That's a new law that was passed not too long ago, just a few months. It's called the Laken Riley Act. And this is something every immigrant, whether you're a citizen, whether you are a green card holder, whether you have papers, especially if you don't have papers, you want to know what this is. It's a quiet game changer that has gone into effect a couple of months now, and is ruining lives of virtually everybody, every category of immigrants. And I want to talk about that tonight as my memo. If there's only one thing you listen to on this show tonight, let it be this memo. You may be innocent, but you may still lose your American dream. I'm going to talk about 5 lessons every immigrant must learn from the Laken Riley Act. So welcome again to the Immigrant Survivor Show. On this show, we are about your survival. We are about how to make it, how to realize your dream in America without a nightmare. Okay, so now what is that? See, tonight, like I said earlier, I want to talk about something every immigrant in America needs to understand. Not because I want to scare you, but because I want to prepare you. This show is not about scaring you. This show is about equipping you for you to survive. Because one thing I have learned after almost 30 years of practicing immigration law in America is this: immigration law doesn't punish ignorance. It simply ignores it and then deals with it. And when immigrants don't understand how the law works, they often pay a very heavy price, and then they blame immigration. So I'm going to start tonight with a story. And I want you to imagine this for me. If you're in America somewhere, or you're planning to come, especially for those of us who are in America right now, regardless of your status. Imagine it's Friday evening. You have just finished a long day at work. 6 p.m., 7 p.m., 8 p.m., you're going home. You're tired. And many of us who are immigrants, we end up that way almost every day because we work so hard to earn that dollar that we send to all those places around the world. You're tired. All you want is to pick up a few groceries and go home to your family. So you stop at Walmart, most likely. I want you to follow this story because it's your story I'm telling and my story. So you stop at Walmart. You use the self-checkout like millions of Americans do every day. You're checking out yourself. Boom, boom, boom. Then maybe one item doesn't scan well and you didn't pay attention. Maybe your child, maybe you have your child with you, maybe it distracts you. Maybe your phone rang and you are talking to somebody on the phone as you are scanning. And then maybe as you're scanning, one of those items did not scan, but you put it in your bag. Or maybe you honestly forgot the case of water underneath your shopping cart. I've seen that. That has actually happened to one of my clients. He had a shopping cart, everything was full. He had a case of water under the shopping cart in the container below, and he forgot. So she forgot. And then Kasala started from there when she got out of the store. It was a Costco. And before you know it, a security officer walks over. Ma'am, sir, did you pay for this? Before you can even think what's going on, 5 minutes later, the police arrive. People are staring. You're embarrassed. Before you know it, you're handcuffed. You keep saying, officer, it's an honest mistake. It's only $3. I have already bought off of $180. So if I want to steal, I'm not going to steal something of $3. You are speaking English. You are in handcuff. You spend the night in jail. The following morning, of course, everybody that knows you at this point, they're running up and down. They got a criminal lawyer. He walks into your jail and says, relax. I've seen cases like this before. It's just a misdemeanor. We're probably going to get the charges reduced or even dismissed entirely. You finally breathe. You think the nightmare is over. Then, just before they release you, you are waiting for your wife to come and get you. Or you are waiting for your husband to come and get you, or your boyfriend, or your sister to come and get you, depending on which one you are living with. Then they call. Your wife is crying. She says, honey, ICE has placed a hold on you. This is not a joke. I'll tell you another story. I'm going somewhere. You attend, this one just happened last week. Attended a graduation for a friend's daughter. And you are driving with an expired license, had a green card, but was driving with an expired license, expired insurance, I'm sorry. A little drink under his breath, then he gets pulled over. He claims that he wasn't speeding, but at this point it didn't matter. He gets pulled over. Give me your insurance and your car note. He had no insurance. Insurance had expired 2 weeks ago. I'm not even sure he realized that. It happened to be one of those states that is not a sanctuary state. I'm not going to give too much detail because that case is ongoing as we speak. The next thing, the officer called, they arrested him for driving without insurance and for having alcohol under his breath. They didn't even test him. The officer just said, you must have been drinking. They took him to jail. The sister brings the insurance. The officer says they're going to charge him to court for drunk driving or whatever. It's like a joke. The next morning, I shows up. He was never even charged officially. And they took him. And right now, he's still in ICE custody. Now, everything changes. I go back to the Walmart guy again. Just a case of water or something that you forgot to scan. ICE has placed a hold on you at this point. The criminal case is no longer your only problem. Now your immigration future, your green card that you already have, that you're so proud of, your visa, your job, your family, your American dream, all of them may now be at risk. Ladies and gentlemen, I didn't just give you Fabu. I just gave you facts of America now. That is the new immigration reality many immigrants still don't understand. Even now. Now, before I go further, like I said, this memo tonight is something every one of us, including myself, need to keep remembering. I'm going somewhere. But before I go further, let me be very crystal clear. Tonight is not about politics. Those who know me know I don't talk politics on this Immigrant Survivor show. I'm not here to tell you whether Donald Trump is right or wrong. I'm not here to debate Republican versus Republican Democrat politics. On this show, I'm an immigration lawyer. My responsibility is much simpler. It is to explain the law as it is to you as it exists, to help immigrants protect themselves from what the law is, regardless of whether they like it or they don't like it, and to prevent small mistakes from becoming life-changing disasters for you. That's why we're here. I'm a very, very politically conscious animal, but I don't talk about that on this show. Because once you are sitting inside an ICE detention center, political arguments is not going to get you home. Knowledge is might. Preparation is might. Good legal strategy is what might get you home. That will be the might that can get you out of there. Now, many of you have probably heard of people talking about something called the Laken Riley Act, or maybe you have not. Meanwhile, your future may very well depend on it. Laken Riley Act is what it's called. Most immigrants have never actually been told what this thing is. So let me explain it in plain English, because there's nothing I hate more than reporters who give you a report, but you don't even understand what they are talking about. I've mentioned Laken Riley 3 times now. Many of you have probably never heard of that law before, but let me break it down for you. Because that law started with a story. Tonight is a night of stories. In February, but this one is a true life story, just like the one about Walmart. In February 2024, a 22-year-old nursing assistant or nursing student named Laken Riley, that's the girl that they named the law for eventually. She was 22 years old, nursing student. She went out for her usual morning run on her campus, the University of Georgia, okay, in the state of Georgia. That's where she was going for a run, and she never came home. She was brutally murdered. The man accused of killing her was an undocumented immigrant who had reportedly had previous encounters with the law before that tragic day. Follow this closely. And if you are, many of you right now, I'm sure you are Googling, trying to find out what exactly is this Laken Riley Act. I'm telling you exactly what it is. It's a story about a girl who was murdered by an immigrant who had had previous encounters with the law. The story shocked America. This was about 2.5 years ago. The heartbreaking case, you see old people crying. People started asking difficult questions. How did an immigrant that has already been deported, what is he doing here? What is an immigrant who had a criminal record? What is he doing on the street? Could something have been done earlier to make sure this doesn't happen? Should immigration authorities have acted differently instead of freeing this guy onto the street? Should they have deported him? Should detention laws be stronger, where that guy could not have come out of jail so that this guy that got killed would not be killed? Those questions quickly became very political. And this is 2024. February. Flow with me here. Those questions quickly became very political. Congress debated them. The country argued about them. Eventually, legislation was passed. Remember, this happened before Trump. So don't say this is a Trump thing. Okay? But when they passed the law, Trump was now in, he signed it into what is now known as the Laken Riley Act. Now, here is where many immigrants become confused. Some people think that this law means every immigrant who gets arrested will be automatically deported, for the few that know about it. But that is not what the law says. Others think, oh, this law only affects undocumented immigrants with serious criminal records. That is also too simplistic. It's not true. Here is the practical takeaway before I now give you the 5 things you must know about this law. The Laken Riley law strengthens immigration authorities' ability and in certain circumstances requires them to detain certain non-citizens who are arrested for specific offenses covered by the law, even before the criminal case has been fully resolved. It's important for you to understand that. Normally in America, before they can use an offense against you, the criminal case has to be resolved. You have to have been found guilty. Then they can use it to try to do something against either to deport you or to take away your green card. But the Laken Riley law is saying no, that you can be detained just because you are arrested for some specific offenses, even before the criminal law has been fully resolved. And I want you to think about that carefully. The conversation in America about crime has shifted. The question is no longer, were you convicted of a crime, which is what they used to ask before this Laken Riley law. Now, sometimes the first question becomes, were you arrested for an offense covered by the law? Meanwhile, anywhere in the world, everywhere in the world, being arrested does not mean you are guilty. Anybody could be arrested. It could be a mistake arrest. It could be whatever. But now it's a big issue. That is a very significant change from the America you know. Now, let me be responsible as a lawyer and say this. Every immigration case is different. Every criminal case is different. And not every arrest leads to detention or deportation. I don't want to scare nobody. Not everyone who is detained will be deported. We have gotten lots of people who are detained out of jail. So don't start panicking and thinking that everything will end up in deportation. No. The law has specific requirements and every case depends on its own facts. But one thing has changed undeniably in America right now. The margin of error is much smaller than it used to be. And this brings me to the first lesson every immigrant should remember about this law. And I'm going to put it on the screen so that you don't forget those 5 things I want to teach you. I'm going to put it here. Lesson number 1, don't ever say it's only a misdemeanor when you get arrested. Before, just a misdemeanor don't mean anything in America. But don't ever say that again. I can't tell you how many times I've had immigrants say, oh, Dr. Ope is just a small case. It's only shoplifting and it happened 30 years ago. Oh, it's only a misunderstanding. Oh, it's only probation. I was in jail. They just gave me probation of 3 months. All right, my friends, there are no small criminal allegations when your immigration future is involved anymore. Criminal court may look at an offense one way, but immigration law, which is what I'm concerned about, may look at that very same conduct completely differently. That's why I tell every immigrant I have opportunity to speak to, never measure your problem by the criminal penalty alone. I'm going to say that again. Never measure your problem by the criminal penalty alone. I've had occasion to tell a husband whose wife had called police on her before for domestic violence, who they never followed through and they never charged the man, that problem is coming. Don't apply for this citizenship. But they didn't take me serious. This was like 6-7 months ago. They thought I was BS, and I said, keep your green card. Now that person, unfortunately, is in jail and has been in jail for about 4 months now. He filed, he did the fingerprint, and they found out that in fact, he didn't even have a fingerprint. He had a record that they were called to the house for domestic violence. And his name was there. So they asked him to come and explain it. They call it, they want some more evidence from him. When he went in there, unfortunately, he admitted that it's true. His wife called the police. but that they settled the matter, it was not a problem, blah, blah, blah. And they handcuffed him. And he's in jail. He's probably going to get out because he wasn't found guilty and he has a green card, I think. I'm not the one doing the case. I found out later that he defied me and went somewhere. But my point is, he's been in jail for 4 months. And he hasn't even been convicted. He was not even tried. Go with me here. So don't tell me it is just a misdemeanor. The way immigration looks at an offense now is very different from the way criminal court looks at it. You want to measure your problem by what it could mean for your immigration future if you're an immigrant. Because sometimes the criminal judge finishes with your case and everything is good. Then the next thing you know, immigration starts their own based on the same issue that you have been freed, that you have even been maybe acquitted, or maybe never even charged. Because the way immigration looks at crime now is very different. It's not just so much because of this Laken Riley Act. It's no longer just about whether you have been convicted, but have you been involved in something that could be called a crime. That's why if your papers are not really very strong, you don't want to be driving. You don't want to be putting yourself in situations where police can come because something else will lead to something else. You don't want to be drinking and driving because they may not bother to test you for drinking beyond the legal limit. All the officer might say is that I smell alcohol on you. And they say it's taking you to the station to go and test you. By taking you to the station, they put your name there. There are immigration officers who check their records. The next thing you know, ICE puts a hold on you. The officer may even release you after checking everything, see that you're okay, but now you don't get released. Or they set a bond. By the way, normally we used to get that. They set a bond for somebody, and then you get the money to go and pay the bond. By the time you get there, they say they can't pay the bond because immigration has detained the person. So don't say it is only a misdemeanor. There is nothing like that in immigration right now. Number 2 lesson you must learn here. When you get arrested, and don't get me wrong, anybody can get arrested. I can get arrested. This is America. You might be driving, you may not hit somebody, somebody may hit you. You may be in a store before you know it, maybe a little argument. In my hotel yesterday, just a simple, I booked a king size room. They put me in a double room. And I got very upset that the cost of a king size room at Embassy Suite is much more than taking a double room. So I went downstairs and I wanted to complain, but they were unsympathetic. And before you can say Jack Robinson, voices were getting raised. Before you can say blah, 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 police has showed up. Thank God I was wearing a suit. That thing could have degenerated to a whole different. The officer now asked me, oh, you speak with an accent. Where are you from original? I know where I was going. I'm like, I'm not going to answer that question. How is that your business? They need to give me my room. But guess what? I started sweating, and I'm an immigration lawyer. I have American citizenship. That don't mean anything right now. So we settled it. They eventually gave me some credit, blah, 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 because I really was like, I'm going to sue this hotel. And because I quickly announced I'm a lawyer, maybe that's why they backed up a little bit. But what I'm saying is that it could have happened to anybody. Imagine if I didn't have papers, or maybe I only had a work permit. And then that guy that came out from the shadows, that policeman, then decided I want to incident that thing because we're yelling at each other at the reception of Embassy Suites. From there, somebody could enter jail and you will not come out until they deport you. So, number 2 thing here, your first phone call when you get arrested, and anybody can get arrested. I didn't yesterday, but I could have gotten arrested. Your first phone call should not be just to a criminal lawyer. This is important. You must also make a call immediately to an immigration lawyer, because most criminal lawyers do not know the immigration consequences of what they're about to negotiate for you. A criminal lawyer may get you out on probation or may get you out on simple dismissal. Meanwhile, the other leg of the dead body is outside with immigration. He has not covered you well because he doesn't know what he's not supposed to plead to. So when you call your immigration lawyer, when you call your criminal lawyer, you call your immigration lawyer, and I don't care whether you have a green card. Call one. And here's why. Criminal lawyers are trained to protect your criminal record. That's the job, to make sure your criminal record is not as bad as it can be. Immigration lawyers are trained to protect your future in America. Two different jobs. Criminal lawyers are trained to protect your criminal record, to make sure you're not found guilty of what you are charged with. Immigration lawyers are trained to protect your future in America. These are two different battles, especially in the light of Laken Riley. I want you to imagine this with me. Your criminal lawyer negotiates a plea that gets you out of jail. Fantastic. You go home happy. 6 months later, you file for a green card renewal. Or maybe you file for citizenship. Or maybe you are trying to file for adjustment of status. Then immigration says, tell us about this conviction that happened 6 months ago. Suddenly, that great deal isn't looking so great anymore. Because immigration law doesn't always celebrate the same victories that the criminal law celebrates. That's why one of the most expensive lawyers an immigrant can hire is the lawyer who never asks about the client's immigration status you want to run. You are speaking with an accent. You hire a lawyer if it was a criminal case, and he didn't even ask you about your status before he started negotiating for you. That one is going to kill you, no matter what he negotiates. Your criminal defense and your immigration strategy should work together from the beginning, not after the plea, not after the sentencing, not after ICE has become involved, from day one. Because in today's America, one arrest can create two courtrooms, one criminal, one immigration. And winning the first one does not guarantee you're going to win the second. Let me give you a good example. Somebody was arrested for shoplifting. And then the the criminal lawyer that she got, negotiated, wait for this, 1 year suspended sentence. Not even jail. 1 year suspended sentence. Guess what? Because the facts were admitted as part of the plea that she did the shoplifting, and then the judge decided, okay, it's the first time, it's not a violent criminal, blah, blah, blah. So they gave her 1 year suspended sentence. In immigration law, that is 1 year conviction. It becomes an aggravated felony, permanent bar, deportation. Meanwhile, if a lawyer had been there, all an immigration lawyer would have done would have been, no, let us negotiate for 364 days, 1 year less than 1 day less than 1 year. And then that will not affect our immigration status. That's simple stuff. And it has happened in real life. I'm not telling you theory. I've seen it several times in our own law practice, in other people's whatever. Difference between 1 day, difference of 1 day, makes the difference between whether you're going to stay in jail until they deport you, or whether you're going to go back home to your family and you don't have immigration case. You can't plead to anything that is 1 year and above. So, and a judge will not have a problem giving you 364 days. It's suspended sentence now. Just removing 1 day will not be an issue. But because the criminal lawyer didn't understand that, and you too, that you want to go back home, you don't want to go to jail, you are happy to take 1 year suspended sentence because the offense they are claiming that you committed, you did it either inadvertently or by mistake, because if you forgot a can of tomato in your box that you didn't scan, that's shoplifting. Nobody cares. It's the law. You didn't pay for it. So that lady didn't really do any serious crime intentionally, but she pleaded to 1 year suspended sentence. And now she's in jail. She's not entitled to bond. And more than likely, she's going to be deported. So When you call that your criminal lawyer, your next call, your immigration lawyer, or better still, when you call your immigration lawyer, asking whether he also practices, when you call your criminal lawyer, you also want to ask him, does he practice immigration law? If he says no, say thank you, call the next one. And if you only got only one call, as you call the person, ask him to help you call an immigration lawyer. Because you need both working together in order to avoid some of the nasty effects of this Laken Riley Act. Number 3 lesson that I think you should learn from this, I see that some of you are already making comments here, but I want to really get into this thing tonight, because to me, it's probably one of the most important memos I'm giving on my show. Lesson number 3 that we all must learn from here. You see, I'm using the word us. No, it's not just you, all of us, including me, teaching this. Sometimes the real punishment is not the conviction. It is the arrest and detention. It's just the mere arrest. Let me ask you a question as you are watching this at home. Who suffers when an immigrant is suddenly taken into custody? Is it just the immigrant? No. It is the wife who suddenly has to explain to the children why daddy is not coming home tonight. It is the husband who is wondering how his wife ended up in detention over what started as a small case. It is the employer who will lose a dependable worker overnight. It is the landlord who will be waiting for his rent while you are in jail. It is the mortgage company waiting for payment. It is a church member who is very active in church but suddenly disappears and nobody knows what happened to her. So, my people, immigration detention does not just affect one person. It sends shockwaves through an entire family or community. Because most of us immigrants, we operate in communities. So that is why I tell immigrants not to focus only on deportation. Sometimes detention itself becomes the punishment for everybody. I've seen families spend weeks trying to figure out where their loved one was transferred. Somebody called me last week, Wednesday. Oh, my husband has been picked up by ICE. What happened? They had a fender bender and they were yelling at each other. And this guy has been in America for more than 20 years. He was one of those DACA boys. And somehow, while they were there, right here in Texas, while they were doing all the argument, police came. The next thing they know, immigration came. They took the guy. And she called me wanting to hire me. This was Thursday last week or so. And I'm like, okay, where is your, it was the fiancé calling. Where is your boyfriend? He said, I don't know. I was just told that ICE took him. They are still trying to figure out where to get him. And this was like 8 p.m. on Thursday. They have picked him at 2 p.m. Unfortunately, I'm an immigration lawyer. I'm a lawyer. I'm not going to get on the road and start looking for your fiancé when you have not yet retained me. I told her what she needs to do for me to start to make calls, to start to go wherever. She didn't call back. I don't know what ultimately happened. But my point is, detention affects everybody. I've seen children asking, when is daddy coming home? And nobody has an answer, not even the lawyer. I've seen people lose jobs they spend years building. Businesses collapsing, savings disappear. Because when this thing happens, it's not cheap. The criminal lawyer will take his cut. Immigration lawyer like Ope Banwo will take his cut. Nobody works for free. And they're not cheap. This is why I'm saying this to the immigrant community so that we can all learn and try to avoid some of these things. Money they've saved that maybe they want to go use to build their house back home disappear, not because they were convicted, but because detention interrupted everything. So whether or not detention ultimately applies in a particular case depends on the law and the specific facts. So some people who are arrested do get released. But by that time, a lot of money has gone under the tail, a lot of pain, a lot of stress. complete with your green card in hand. I remember seeing somebody about, I think that was like maybe 8 months ago, totally stupefied. He has this disbelief on his face because he has had green card for 9 years. And in his mind, that green card protected him from everything. And he's wondering, why is he still in jail 5 weeks after? And I had no answer for him, other than to be telling him, that's the law here. We are trying to get you here. We have been trying to get the judge. They denied the firstborn. We are trying to get the second one. That is what Laken Riley has done. Every arrest now deserves to be treated seriously from day one, immediately. Because today's enforcement climate places far greater importance on what happens immediately after an arrest than many immigrants appreciate. In states that are not sanctuary states, some of them will actually call immigration. And with Laken Riley Act, they're going to detain you, especially if you had some record before you've had arrest. Number 4 that you should learn here. I know before, when you get a green card like that young boy that I met in jail, who was still stunned that after 9 years, after being in this country 20 years, and I had a green card for 9 years, he could still be in jail for 6 weeks while they are trying to get him out just because he was arrested. He wasn't even found guilty yet. That takes us to lesson number 4. A green card is not a suit of armor, so you need to respect yourself. That's the reason why I'm saying this stuff. We need to respect ourselves as immigrants. I'm not here to tell you whether the law is good or the law is bad. That is not relevant on this show. You just don't want to be in jail. That's why I'm saying this. Don't go and be getting overzealous because you have a green card. A green card is not a suit of armor. Deportation bullet can still penetrate after they arrest you, even if you have not yet been convicted. And this one surprises many people. Some green card holders honestly believe, oh, I'm a permanent resident now, immigration is behind me. Even citizens, you have that 250 of them were just charged last couple of weeks. They want to take away their citizenship for different reasons that you would not even think will happen last year. No, with your green card, immigration is not behind you yet, even with your citizenship. Permanent residence is exactly what the name says. Residence, not immunity. Now, don't misunderstand me. I'm not trying to scare nobody here. I'm not the prophet of doom. My own is to make sure you understand the reality. The overwhelming majority of green card holders who obey the law, who work hard, and who live responsibly have absolutely nothing to fear. I don't want anybody to feel under siege. If you are running your life well, if you are obeying the law, and you have a green card, you have nothing to fear from America. But like you and I know, things can degenerate quickly. Before, it won't be an issue. But now, it can be an issue. That's why we all need to be very careful. Let's say you are married or you are living with somebody and things start to get out of hand. Just shouting at each other. Neighbor can call police. Before police will come, everybody talk their own, and then police will go, especially if the husband or wife is not pressing charge. Even if there was violence involved. We Africans or immigrants, we have our own thing that we do. Maybe a husband slaps a wife, the police comes in. The wife is not going to be saying, take my husband away. It's probably going to say nothing happened. They will settle it in their family or whatever. But somebody calls police. And before you know it, it's a whole different thing you are dealing with. So I'm not here to create unnecessary panic. But I'm here to destroy dangerous assumptions. Because certain criminal conduct can still affect your green card, your eligibility for citizenship, your ability to travel internationally, essentially your future in America. When somebody tells me, oh, Dr. Ope, I've had my green card for 20 years, I laugh. My answer is always the same. I'm happy for you, but let's protect it. Getting your green card is not the finish line. Keeping it is. Even getting your citizenship is no longer the finishing line. Donald Trump just proved it. He's proving it every day. I read today, I think it was 25 or whatever, that they're for different, some of the offenses that they're trying to use to take their citizenship will blow your mind away. Laken Riley Act is one of those things that has made all of these things possible, and we need to be very, very careful. We may be citizens, but we are not. I'm sorry to say this, I'm one, and I understand who I am. I'm not thinking like I'm a citizen now. I have the same rights as somebody who was born here, like my children. Our rights are different. I tell my kids the same. My own are blue passport I carry. Your own, you are born into blue passport. So don't bring your wahala to me. They are different. When an American commits a crime or is arrested for a crime they didn't commit, when they finish in court, they finish in court. I'm talking about the ones born here. You that you are not born here, you finish in court, then you are starting with immigration on matters normally that is nothing. Yes, it's harder to take a citizenship. They have to take it to federal court, and there's a lot of court case that has to go in there. But green card holders, you want to be more careful. This is not the season. Laken Riley is telling you that. Finally, the fifth lesson before we go into the update of the week, and we have some very amazing updates coming up soon. Lesson number 5 here. When you get into a criminal situation, again, when we talk this like in Riley, a lot of people assume they're talking only about criminals. Those that are losing their green cards over it, many of them are not criminals. So, Laken Riley Act, lesson number 5. Don't wait until ICE is involved to seek help. Don't be underestimating the criminal issue you have, even if it's ordinary speeding. Try to settle it quickly. If they give you a fine to pay quickly, and before you plead guilty to anything, make sure you talk to an immigration lawyer, not a criminal lawyer, unless the criminal lawyer is also practicing immigration law. They call them crimmigration. Those who are doing crimmigration, in other words, they know immigration and they know criminal law, so they can advise you well on which of the pleas to get. But don't wait until ICE is involved. We have a situation of a guy, or had a situation of a guy who went to court. They fought in a nightclub. I'm talking, this was about maybe a year ago. They fought in a nightclub. Young guy, maybe 19, 20 kind of thing, the way young boys are fighting over girlfriend in court. So they boxed themselves at the club. Police came and arrested all of them. And they put him on a bond. I think it was, the judge gave him a bond for 5,000, meaning that he has to pay 500, 10% to come out. Now, instead of them posting the bond immediately, like we advised them, they were dilly-dallying. The father was saying, well, I really don't have the money to get. I will get him in 2 days. He was there. By the 3rd day, ICE came in. He's in Mexico as we speak. But they found out that now that those boys that he was running around with, a couple of them were in a gang. The next thing he knows, they're charging him under gang, blah, blah, blah. The next thing he knows, he's gone. So when you find yourself in a criminal case, whether it's an arrest, whether it don't matter whether you believe you are innocent. What I'm saying is that you want to quickly get it resolved, get a criminal lawyer, get an immigration lawyer on it, and try to get yourself out of there before that database cools down. With what Elon Musk has done now, that database could activate. Oh, yes, thank you. I saw the Instagram, they were live there. So could activate ICE because they are all lingering around. Many of them have quotas now. They are checking out the way reporters, the way reporters used to check police record or police alert to find out whether something has happened so that they can get a story. The same way ICE is checking arrest now. You saw in the news last week. I don't know whether it was Georgia or whether it was Atlanta. It was Atlanta or wherever, where they arrested a lot of people who came to court, criminal court, for one thing or the other. They got the court records and saw that a lot of these people they are bringing, I think they're Somalians, maybe like, I don't know, 60 of them, and they were waiting. Later they are there over nonsense cases, maybe what they call it, walking around and just, but they picked them from there. So you don't want to put yourself in that situation as an immigrant. Because this number 5 may be the most important lesson of tonight, the 5th one. I mean, I've practiced immigration long enough to notice a pattern. Most immigration disasters do not begin with bad people. They begin with delayed action. People wait. They hope the problem will disappear. They listen to friends. They ask Facebook. They ask WhatsApp. They ask the Baba. Everyone has a different opinion for them, but very few ask the right answer. But instead of taking action, 6 months later, they walk into my office and they say, Dr. Banwo, I wish I had come sooner. And sometimes when I hear that, my heart sinks, because by then, the plea has already been entered. The statements have already been made. The deadlines have already passed. ICE has already become involved. Now what we are trying to do is prevent damage. We are not preventing damage. There is damage now. What we are trying to do now is to reduce it. And that's why I always say, the cheapest legal advice is the advice you get before you make the mistake, not after. I was on a consultation today and I was very happy because the gentleman had an expiration coming up soon. But unlike many immigrants that I know, they wait like 2-3 months before the expiry date. Then they start running up and down. He's already saying, what will I do? My stop expires in 6 months. That is how you want to be thinking now in America. Because once that thing expires in your hand, everything changes. Don't wait until ICE becomes involved. The cheapest legal advice is the one you get before you make a mistake. Is the one you get before your status expires. Is the one you get before you make a plea. Is the one you get before you do anything. Even if it costs you some money. Because after problem has started, lawyers are not talking to you about 2,000 anymore. They're not talking to you about 5,000. They are talking 10,000, 20,000. I've seen a colleague charge somebody 50,000 for a problem. You don't want that. You want to pay $100. Talk about it. At least you know what you are doing before you make that mistake. So that way you avoid all this expensive thing that you don't want lawyers to then pick you apart. Now, before I close, let me say something very important. I don't want anybody leaving my program thinking I'm telling immigrants to live in fear. I'm not a prophet of doom. I said that at the beginning. That's not my message. Fear has never solved an immigration problem. It has only made it worse. So don't be afraid. Preparation is what solves problem. Knowledge is what solves problem. Honesty about your situation so that you can find the right solution is what has solved problem. Don't be lying to yourself when you know you have no status or you are not working out to change your status and tell everybody you are okay. That would be stupid. Good legal advice is what has solved problem for people, not WhatsApp advice. Okay, a lot of the people who are giving you advice on WhatsApp about immigration, they themselves will have no papers. All they've done is maybe they've got to go Google ChatGPT. Sometimes ChatGPT doesn't get it right. I know because I Google ChatGPT all the time. I've had to argue with it sometimes. There was one particular immigration development I was asking that, and it was giving me wrong information that I know was wrong information. And I'm prompting it, and it's giving me the same answer until finally I had to go get a link somewhere and give it. And I said, oh, I'm sorry that this kiniko. A lot of people giving you advice, they're not lawyers. Even if they got it right from the ChatGPT or Google or Gemini or wherever, having the raw facts is different from being able to translate it like a professional. So don't wait until ICE gets involved. Good legal advice is critical. And I'm not saying so that you can come to me. Go to any lawyer you can find. But it would be stupid for you to do anything in America today as an immigrant and you don't talk to a lawyer first. The overwhelming majority of immigrants in America are very decent, hardworking people. I know. I'm around them all the time. They came here to study. They came here to do business. They came here to become nurses. They came here to become truck drivers, engineers, teachers, doctors, pastors, whatever, entrepreneurs. They came here to raise their children, to contribute to this country so that they also can make some money to go back home and build houses. And they deserve to know the rules that govern the country that they now call home. Because America is now our home. You can cry about Nigeria you want, you can cry about Togo all you want, but you live here. So this is your home now. So you need to know what's going on. That's why I wanted to talk about Laken Riley tonight. And that's why I do this show. Not to frighten immigrants, but to prepare them. That's why I spend a lot of time on my memos. Instead of jumping to question and answer, anybody can answer question for you. But you need knowledge that can help you grow as an immigrant to prepare you. Because here is what I know after almost 3 decades of practicing immigration law. The immigrants who succeed are rarely the luckiest or the most prayerful. They are the ones who stay informed. They are the ones who ask questions early. They are the ones who don't assume anything. They are the ones who prepare before a crisis. So I'm going to leave you with 3 final thoughts, because it's getting too intense tonight. Number 1, never assume that because a criminal case looks small, the immigration consequences will be small. Sometimes the opposite is true. The criminal case is small, but the immigration consequences are huge. Sometimes the criminal case is big and the immigration consequences are small. Number 2, never let your criminal lawyer fight your battle alone if your immigration status is at stake. Make sure an immigration lawyer is part of the strategy from the beginning. Don't finish with the immigration lawyer, don't finish with the criminal lawyer and then go look for the immigration lawyer. Sometimes that's too late. They got to work together. You got to put them together before you finish your criminal case. Otherwise, it will be disaster. And number 3, whether you support Laken Riley Act or whether you oppose it, that's a political discussion. It's not for this show. Whether you understand the Laken Riley Act is a survival discussion. You have to understand it. Then you can form whatever opinion you want. The law exists. They are not proposing the law. The law has been passed. The law has been signed. And smart immigrants don't survive by pretending reality is different. They survive by understanding the law, protecting their families, and making wise decisions. Because in today's America, one arrest can create 2 battles. One in criminal court, one in immigration court. And winning the first one does not always mean you're going to win the second. That's all I got for you on my memo tonight. Hopefully, you can talk to your friends. If this doesn't affect you personally, protect your family, protect your future, protect your American dream. Because it's far easier to prevent an immigration nightmare than it is to fix one. I know I'm the Immigration Rottweiler. I know my job is to help you avoid the nightmares. Thank you for joining me. When I come back, we're going to go to the immigration brief, and I'm going to bring you the latest immigration developments across America, because every day you wake up in this nation, something new, something different has happened. And today is not an exception. Several things happened at the Supreme Court today. Some of it will blow your mind. Some of it will affect your very existence in America. But I'll bring it to you right after this short time out, where I talk briefly with you. I came to America myself for some of the stuff that you are here for. Listen to me. I did not come to America looking for opportunity. I came here running for my life. Soldiers were looking for me in Nigeria because I spoke out against a military dictator. But when I finally arrived in America, I was too afraid to even ask for help. See, in the early 1990s, Nigeria was under a military dictatorship led by one General Ibrahim Babangida, and I was a young lawyer and a pro-democracy activist speaking out against the regime. After organizing a national conference on the role of women in the promised Third Republic, a democracy that the dictator had promised but later reneged on, I was arrested
and briefly jailed for about 10 days. When I was released, everything in my life practically began to collapse. My business, my peace of mind, my ability to live normally. Soldiers were looking for me. I lived every day wondering if I would be arrested again or maybe simply shot, as many were.
Alrighty. Well, that's just the beginning of my own story to America. And you want to go to my website, banwolaw.net. You get the full video there, or my YouTube channel, Banwo Law, that I just created. For our new office there, you see the full story there. I also was going through some of the emotional trauma some of you are going through. How I was able to solve the problem by confronting my problem and all that. And I think it will bless you. Every year, millions of immigrants come to America chasing a dream of opportunity, a dream of a better life, a dream of becoming something more. But what many do not realize is that the journey is filled with confusion, legal traps, and costly mistakes. And that is why this show exists. This is the Immigrant Survivor Show with Dr. Ope Banwo, where we provide information to help immigrants achieve their American immigration dreams without the nightmares. Pay attention as we break it all down for those who have ears to listen. Okay. Hope you're enjoying the show. Again, with me on the show tonight is Grace Okafor, Jolomi, and Samuel Upon in the back room, rocking it with me tonight. Thank you guys so much for all you do on the show. Appreciate you so much. All right, we are going to the second segment. I love that first segment because I always like to be very detailed about this. So it's almost the longest part of the show. But let's talk about some of the updates that has come down the wire in the last few days. You know, because you wake up, before you close your eyes, something more has happened. Today was one of the biggest immigration news days of 2026 because of the impact of what just happened with the Supreme Court. Excuse me, because the Supreme Court handed Donald Trump, the administration, two major immigration victories in one day. And if you're an immigrant in America today, today's rulings demands your attention. Not maybe, it's something you should pay proper attention to. So let's look at some of them today. The first one I want us to look at is the Supreme Court's decision that just came down. Where is that? Yeah, the one on asylum. The Supreme Court decision saying that asylum rights generally begin after you enter U.S. soil. You know, they've been battling it, whether you can file asylum if you're at the border, like Mexico on the other side, and all of that. And they've been battling that case for a while now. But today, the Supreme Court said the Trump administration is correct, that your right to claim asylum only begins after you have entered America. Meaning that now, ports of entry may turn away people when they say it's full. Now you can get to the airport and raise up your hand and say you want to file asylum. That's in those days, that's what a lot of people were doing. Okay, where they get to the point of entry because they don't have any papers and they are really afraid for their life, or at least that's what they claim. The advice is that once you get to the point of entry, as soon as the immigration officer comes near you, you just raise up your hand and say you are afraid of your life, you want, and they will let you in, and then you file your asylum, and then they might charge your case to court. But the Supreme Court says, So what exactly is this update? I call it one of the biggest immigration decisions of the year. It doesn't feel like that. For those who don't know the immigration regime in America, to me, it's one of the biggest immigration decisions of the year. The only one that will surpass it is when Supreme Court finally give their ruling on birthright citizenship. But today, on the 25th of June, the Supreme Court ruled that federal immigration officials may turn away non-citizens who arrive at U.S. ports of entry without valid documents when those ports are operating at capacity and the individuals have not yet physically entered the state. They are not saying they should turn all of them back. This is, they say when they are operating at capacity. In other words, if you enter through Canada and your whole hope is to come and declare asylum as soon as you get to the point of entry, they are saying they are busy. If the place is arming, they can turn you back. Supreme Court said that, not me. Now, why does the decision matter? It matters because the decision reinforces a very important legal distinction that many immigrants misunderstand. There's a legal difference between someone who has physically entered the US and someone who remains outside requesting admission. When you present your visa or whatever paper you have at the point of entry, you are requesting admission. The fact that you have a visa or don't have a visa is not admission. When you present your passport, you are requesting admission, and there's a big difference. The court ruling now says that the government has greater authority to manage overcrowded ports of entry before individuals are admitted into the US. I want to be clear because there's going to be a lot of rumors going on. The decision just came out today. There's going to be a lot of WhatsApp lawyers out there talking rubbish. This decision does not eliminate asylum, even for those who are arriving. It only clarifies when and where certain asylum protections become available. I'm going to say it again. It did not eliminate asylum. It did not say arriving aliens cannot file asylum. It only clarifies when and where they can file it. Here is my own strategic recommendation here. Don't rely on social media rumors about asylum law. Understand that, number two, understand that where you are physically located can dramatically affect your rights. So maybe if you are coming to the country, if you're outside the country watching this, maybe you don't want to come in through very busy ports so that they don't come and say the place is too busy. You want to come through areas that are not traditionally very busy. If you believe you qualify for asylum, obtain legal advice before presenting yourself at the U.S. port of entry. It is better to call in, talk to an immigration lawyer from wherever you are before you actually present yourself at the port so that they can advise you well how and where to go present yourself. So that way you reduce the risk of being turned back at the point of entry. Because the bottom line here is that small legal decisions often produce enormous immigration consequences. Supreme Court just reminded us today that in asylum law, where you are standing can determine what rights you have. If you're coming through JFK, when they are very busy, they may just send you back. If you're coming through Minneapolis, for instance, and they're not busy, they may allow you to come in and file your asylum. See what I'm talking about? It is now a strategic decision where you decide to come into the US. That's update number one. We are still unpacking it. The Supreme Court just gave the ruling today. Of course, we are going to be digesting the full ruling more over the next few days. And if anything changes about my position, I will let you know. But for now, that is the summary of it. Update number two that also happened today. The Trump administration has been trying to end TPS for Asians and Syrians. And this is serious because if you're an Asian or you're a Syrian, this is not child's play. This basically is affecting your American dream right now. So what is that update? The Supreme Court ruled today that the Trump administration may move forward with ending temporary protected status for Asian and Syrian nationals while litigation continues. For those of you who may not know much what this is, TPS is called temporary protected status. When you are given it by the government, it protects you from being deported, and it allows government to give you work permit to work while they are while you are in that status. Now the Trump administration has been trying to, it has ended for some countries. They ended it. It has been trying to end the one for Asians and Syrians, and a lot of immigration lawyers and a lot of Asian nationals, they went to court to say he can't do it. So normally, while the case is in court, the government will not be allowed to end the TPS, the temporary protected status for them. But Supreme Court just ruled today that the Trump administration can end it, even though they are still in court. Things are happening in this country. That's all I'm going to say. Your own is to understand what the law just said. Whether I approve or approve, there are forums you will come, you will see me talk about what I feel about it. But as an immigrant lawyer, it doesn't help you for me to get involved in all those discussions about politics. It's how are you going to escape? How are you going to survive? So know this. Supreme Court just ruled that the Trump administration can move forward with ending TPS for Asians and Syrian nationals while the litigation continues in court. And this is the TPS that allows eligible nationals of several countries that America has designated, especially when they're experiencing war, disaster, extraordinary conditions, to live and work legally in the U.S. Okay, they are going through extraordinary conditions. It allows them to live and work legally in the U.S. on a temporary basis. Why does this matter? Like I keep saying, this is one of the year's biggest immigration rulings. If they can rule it for Asia and Syria, almost any country that has TPS now, you know, Trump can stop it at any time. And remember, TPS is not a permanent immigration status. It is temporary protection. And the minute they take it away, that means you are subject to deportation immediately. That means you lose your work authorization. That's what it means. Now, I need to be clear. Trump administration has not canceled the TPS for Asia, 80 people, and Syria. Supreme Court has just said they may do it if they want now, meaning that you're probably going to see them do it tomorrow or next tomorrow or whatever. But this is a survivor show. What do? My own strategic recommendation, if this is affecting you and it's going to affect a lot of Asians, and you know there are plenty in Florida, there's a lot of them in Dallas, in Texas and all those places. My strategic advice is for you is don't wait until your TPS expires. Even if you're in a country with a TPS and you're not under the radar yet, don't wait until your TPS expires. Start building your plan B now. That is the most thing that frustrates me a lot about many immigrants. They don't think about their plan B until they need it. No, you don't think about plan B when you need it. You think about it in advance. That way, your plan B can be at an advanced plan before you actually need it. You now want to start exploring family petitions, employment options, asylum, other forms of relief like T visa, U visa, some of those visas that are out there. Talk to people. What can you change your TPS to? What is the other status you can pursue now? Some of them, you have to set up yourself for it. It may take you months to put all the ducks in a row. Some, you need to do some work. Some will cost you money. You need to start looking at your plan B right now. Because now that they've been given permission that they can do it, you know they're going to do it. We don't need to be staying here talking about it. In the next 1 week, you know your guy is going to do it. So you don't want to be caught with your pants down. And when you have TPS, and there's so many countries that have it now, always view it as a temporary protection that it is. It is not a permanent immigration strategy. I know people on TPS, they've been on it for 7 years, and they think that's the permanent solution. Now with Trump now, they're telling you that the thing can go in one night. You need to have your plan B. All right, that may not affect everybody, but those hundreds of thousands that are about to face Pepe, this is probably the biggest news to come out of America this year. Update number 3. I don't think this one will surprise anybody. The DHS is signaling that they are going to be even more stronger on immigration enforcement. They've just been giving money. Okay. So they continue to highlight expanded immigration enforcement operations. They are increasing fraud investigations and ongoing efforts at targeting immigration violations worldwide. I'm going to repeat that. They are increasing efforts targeting immigration violations nationwide. The message from DHS is very clear. Immigration enforcement remains one of the administration's highest priorities. I don't think that is surprising anybody. Donald Trump said that many times before he became president. Now we are all taking him serious. More enforcement resources generally mean, because they've been given a lot more money and resources now. What does that mean for you? More ICE operations, more fraud investigations, more worksite enforcement, more immigration compliance reviews, greater scrutiny of immigration applications. That's what it means. They have people to actually take time and study them now. So here is my own strategic recommendation. Again, first, do not panic. Panic can't help you. Prepare. Review your immigration case today with your family. If you don't understand it well, go get a lawyer to look at. Right now, if you are talking to a lawyer to help you review your case, there's hardly any lawyer that will charge you more than $250. Most charge $150, $200. I charge only $100 for consultation. You need to go do that so that you can even know where you stand. You need to do that in the next few days. Of course, if you want to speak to me, you can always go to speakwithope.com, but this is not about me. Please, this is about you grabbing the best immigration lawyer you can find in your area. And I'm sure every one of us have an immigration lawyer in our neighborhood. If you don't want to book it with me, I represent people nationwide. We can talk on Zoom, or if you want to come directly into our office. But I'm saying this is not about you coming to see me personally. My advice is go get strategic advice on your case from a lawyer that knows what he's doing. Review your immigration case. I'm surprised at how many immigrants I meet who are not clear what their status is. I met 3 different people in Houston last week. 3 different people, very intelligent, very educated, very well connected. They came into this country. All 3 of them in the last 1 month. I went to see one at a different hotel. I went to see one in the house, and one other one came to see me. Guess what? Only one of them know how long he has been given to stay in America. The other 2, I asked them when does the I-94 expire. They have no idea. Because they don't tell you at the airport anymore. Before, they used to give you a white card that would tell you it's called I-94. That I-94 would state how long you're allowed to stay in the country. But when you come in now, they don't give you an I-94. They don't give you anything. They just give you your passport back and say, welcome to America. Meanwhile, the man has said whether he wants to give you 1 week, 1 month, or 6 months. You are now supposed to go to the Customs and Border Patrol website, the CBP website, to go put in your passport number, then print out your I-94 yourself so that you know how long you have been given. Can you imagine that? What that means then is that, in fact, the one that knew the day she was supposed to leave was very lucky because she decided to do that. Because everybody normally assumes they will give you 3 months or 6 months, especially if you have been doing multiple entry to America, you have had multiple visas. It turned out that they gave her only 1 month. Meanwhile, she was planning to stay for 3-4 months to do some tests. But thank God she went in there and checked, and she saw it. And she called me. That do I apply for extension, and I have to then give her an advice about what to do or not do. The other 2, I met one where we went to eat. I was like, oh, we all high-five each other. I knew from way back. Yeah, I just came in 3 days ago. I came for this, I came for that. Okay, I'm like, okay, when are you going back? He said, oh, I'm going back. Mentioned that I want to go and see this one in San Francisco, blah, blah, blah. I plan to stay like 3 months. So I'm like, did they give you up to 3 months at the point of entry? It was like, no, I have a 2-year visa now, that my visa doesn't expire until 2027 or something. I'm like, are you kidding me? This is somebody that is a CEO of a big company. Okay? I'm like, what are you talking about? That your passport doesn't matter. It is what they gave you on your I-94 that matters. Once you have come to America, your visa from Nigeria doesn't count anymore. It is what that guy at the port of entry gave you. He said he doesn't know. I'm like, what do you mean you don't know? And then I had to tell him to go to the website. I had to give him the website address to go and check. It turned out I was 30 days they gave him. So if he had not met me at that bar and nobody has talked to him about I-94, he would have gone to San Francisco, maybe spend 2 weeks with his friend, go to Cincinnati, spend another 2 weeks. By the time he's done, in his own mind, he wants to go back in August. But his visa expires, I think, on the 20th or 18th of July. It came in on the 19th. So, people, this is no longer a joke. They are enforcing these laws now, and nobody cares. You have to understand that. We are still here, okay? Nobody cares that you don't know. My strategic advice, as I'm repeating on this, they want to enforce their law better. Your own part is to know the law well, so that you are not stammering. When they say, why did you stay 2 months? You are saying, hey, but I have multiple entry visa for 2 years. You're going to look like an idiot, because then you won't be able to come back again. Then all sorts of problems attend your life. You don't need that. So if you are listening to this, what I'm saying in this strategic advice is that know your immigration status. Don't panic. Review your immigration case. How long do you have here? How long have you been illegal? For instance, let's say your visa has expired, your I-95 has expired. You know that if you are less than 6 months before you leave, you'll still be okay. If you are more than 6 months overstay, but less than a year, if you go out, you can't come back for 3 years, even if you marry an American citizen. You know that if you have been illegal for more than a year, you know it's 10-year bar unless you get a waiver. That even if you win lottery, even if you marry an American citizen, you can't come back for 10 years unless you get a waiver. It don't matter what your status is. The important thing is that you know what it is. And you know what it is by talking to a specialist, not assuming. It's like some students who have not gone to school. They have F1 in their hand, but they did not carry full load last semester. What they didn't know is that automatically they've lost that F1. It's just in their hand. Because the rule of F1 is that if you didn't carry full load for a semester, then it's voided. Even though they may not send you a letter now, it is when you want to get a renewal that your life will be clear. I've also met a student like that. I said, listen to me. You need to go back to your school. You need to go take full credit now. You can't say, I don't have money, or I want to do. You came as a student. You have a student visa in your hand. You must go to school. So don't panic. Again, that's why I do this show. That's why I spend a lot of my time on these updates and on the memos, because most of the questions we're going to be answering is questions that other people ask for themselves. People can go see lawyer to get their questions answered if I don't get to it today. But this general education thing is why I'm doing this. It's my own service to the community, educating as many of us as possible. So this is your strategic advice. Review your immigration case. Know what it is. If you're a visitor, know how long you have been given. If you're already on a status, know when it expires. Know what you need to do to keep that status. And part of your strategy is to fix unresolved immigration issues before they become emergency. See, if you are not yet in an emergency level, people will listen to you. What they charge you is going to be smaller. It is just demand and supply. Immigration lawyers are not wicked. They are human beings. If you are in an emergency, they are going to charge you emergency money. But if you are not yet in an emergency, then your fee will be reasonable. It's just the way it is. Even you are beyond the money, even you to be able to sleep. If you are trying to fix your problem when really there's no emergency, like that gentleman that I consulted with, I was very happy he called me. Because he has a runway now, maybe like 6 months to try to figure something out. He's not on an emergency level yet. He can still do something without him sleeping and being afraid whether immigration will come and knock on his door. So that will be my strategic advice for you on this update number 3. Immigration is already determined that they want to increase enforcement. Trump has now given them plenty money in the last 2 weeks, Congress has approved it. So you know they're going to do it. Don't stay in your house. And like they say, a word that is pre-declared does not catch a cripple unawares. Start figuring out what your options are. For some of you, your options might be just go home for a while and come back. I gave that to somebody last week. Now, no, you can't use this visa to try to say you want to do extension. You're going to enter another problem. It is better, even if it is Mexico, you're going to go. Even if it is Canada, you have a multiple entry visa. Go and come back with it. For some of you, it might be trying to change your status from where you are now to something else by being more aggressive about pursuing it. What is enough? Let's look at update number 4. Now, on the heels of what DHS is doing, even worldwide, nationwide now, and globally, the State Department continues to crack down globally on visa fraud. Now, remember, the State Department is one that handles visas outside the country. When you are dealing with the embassy outside the country, that's not US DHS, that is State Department. A lot of people don't know that difference. See, the State Department has announced that it is expanding efforts to detect visa fraud worldwide, including, wait for this, my brothers and sisters from my country, fraudulent documents, fake consultants, coached visa interviews, organized immigration fraud schemes. Consular officers are now using more sophisticated fraud detection tools and sharing information nationally and internationally. Why does this matter? Visa applications today receive far greater scrutiny than in previous years. So applicants should expect more background checks. I always tell my clients now, whatever you are going to be submitting, make sure it is backstopped. Meaning that if immigration go there, will they meet it as you have just given me? Oluwole doesn't work again. You can't get away with it because they use local people like you. It's not that it's white people that will be going to go look for. They use your neighbors. I know I've had plenty of clients. I've been doing this for a very long time, so I know how this thing works. They use regular people that you yourself will let into your house, or people that can be able to talk to neighbors. We have seen reports of those who divorced in Nigeria, who went their separate ways, married American people, which ordinarily before is not a problem. As long as you get your documentation right, they will approve both of you. But they went to the house, to the field where the kids were playing, to ask about them. And then they were hearing they came for Christmas last year to that house, the same house that they were supposed to have divorced, everybody gone their way. They were there. I'm not giving you a hypothetical. I'm telling you a situation on ground for somebody's client. What does that mean? Again, it is once you are aware, then you can protect yourself. This is not, I'm not telling you this for you to panic. I'm telling you that they are doing more background checks. You can't just go get a divorce certificate from one clerk and then you go and submit that to them and you think that you're going to get away with it if it's not a real divorce. You got to go through the right channel. You got to do it right because everything is being checked, including bank statement. You know that now they have access to the bank statements of the bank accounts. Sorry, they have access to all the banks. Don't let the banks lie to you that they don't have access. It's a lie. Most of them already have arrangement with them. They will send your account number or they connect it and they'll be able to tell whether the statement you brought was genuine or fake. This is not to make you panic. It's simply to say, make sure that everything you are carrying around in your immigration stuff is genuine. You know, it is traceable. It is auditable. That's all I'm trying to tell you here. Your certificates will be verified properly. Your divorces will be verified. Your children's birth certificates will be verified. It's no longer just talk. In fact, so that you understand this, many applications you file in America and they make you pay what they call visa fraud fee. So that they can use that money is what they are using to do investigation. $500, for instance, for L1. $500 is a lot of money in Nigeria. That's $750,000. So they can pay somebody to go to your office and go and talk to your staff And if you are putting stuff that are not real, they're going to catch you. So you have to properly document everything that you're doing and make sure that everything is auditable. So here is my strategic advice on this, because to me, it's about survival. At the end of the day, that's what this show is called. The Immigrant Survival Show is what we call it. It's how to help you survive immigration in America. So here is my own Rottweiler strategic recommendation here. Avoid immigration shortcuts. Shortcuts will only get you into more trouble. Take your time. Don't use fake documents. If you are going to submit the document, then make the effort to get a genuine one. Do not rely on visa fixers. Many of those visa fixers are under investigation, in case you don't know. I know, because this is my business. And when you may even get away with it. And I know people who have gotten away with it. They've gotten their visa. They even got green card. Then when they take down that visa fixer, do you know what happens, guys? Every visa that he has gotten for people will be nullified. It don't matter if you have now become a green card holder, they are taking you down. They don't care if your own is clean. You don't have to take my word for these things. You can research it. So the fact that somebody is collecting money from you to help you fix your visa may sound good today. You may even get it to America. But just when you have settled down, just when you think your life is on the right track, they catch the person. And then all the records of people that he has ever helped, they come and contact everybody and they put you in deportation proceedings. It's happening. Or if you are lucky, all they will do is just cancel your visa, because they don't have time to chase everybody here, but they've collected money now. I won't be surprised if they start going after more of them. Before, what we'll do is we get letters saying your visa has been cancelled because the person who got it for you has been involved in fraud, blah, 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 and they just leave you to your life. They don't charge you to court. But more of them now that they catch will be charged to court. Why? Because they have the money, they have the staff. They just hired 350 new judges. They have the personnel. So you don't want that. So the minute you even hear that somebody is a fixer for your own preservation, don't deal with him. Deal with professionals. If it's going to take you time, then take the time. I have a client once who, part of what he wanted to use to qualify is that he has published articles. And he was going to go like arrange somebody to help you. I'm like, no, don't do that. It may take another 3 to 6 months. Write the articles now. Articles are not hard to do. Write it and actually publish it for real. If the article is good, you take it to Google and got plenty magazines who will even pay you money to publish your article. Do it right. Yeah, you won't have to submit your paper today, but in 6 months, you'll be ready. So that those articles are there. Let them go check rather than go do one arranged thing and pay somebody to just talk something in the newspaper, one little corner where there's no depth, you have no book published, you have no publication in the right places. That's what I'm saying. I'm not saying you still can't fix stuff, but fix it right. Because the same person who arranged a fake article can write a good article. Why not write a good article and go get it published? That's all I'm saying. You don't panic. You just want to avoid quick fix. You want to avoid shortcuts. Bottom line here, immigration fraud has a very long shelf life. A shortcut today can become a denial or worse later. You don't want to do that. And finally, let me get the 5th breaking news for today. USCIS reminds immigrants to report address changes promptly. This looks very deceptively, whatever, but they have very big consequences. You have to report your address changes if you move, if you change house. What is this update? The USCIS, that is immigration. Me, I don't like to use abbreviations because a lot of people don't follow it. Immigration continues reminding immigrants, and they sent out one today, that most non-US citizens are legally required to notify immigration of a change of address within the required time frame after moving. Failure to upgrade an address can result in missed notices, interview appointments, requests for evidence, or even missed court notice, because they're going to send it to your old address, the address that they know. If you don't change it, then you're your own. This matters because many immigration cases are delayed or even denied, not because applicants were not eligible, but because they never received important government correspondence. And I see that a lot with many of us African immigrants. Because we are paranoid, we don't want to give immigration our right address. So because we think that maybe they will come to our house, so we give them an address that we don't live in. And then maybe we quarrel with the person who's collecting the address for us. And then that one collects letter and tears it. Or maybe doesn't see it. And then they call you for interview. I've seen several of that this last year. Some of them my clients. One of them was using an address of the in-laws of our husband. And somehow they didn't like her. I don't know what they were doing among themselves. When letter for immigration came, they were not giving it to her. Eventually, she has been charged to deportation court because she missed interview notices 3 times. It's crazy. When you move, you got to tell immigration. It doesn't mean they're going to come to your house for you. As long as you are showing up, immigration doesn't come for you. So here's my own advice. Remember, I tell you what the update is, and the update is not useful to you if I don't tell you how to deal with it. So here's my advice. Update your address with immigration immediately. If you're an immigration court, update the URR, is what they call it, that's the court. Update them separately. Don't do mail forwarding. Don't assume that mail forwarding automatically updates your immigration record. It does not. And guess what? A lot of immigration papers, when they send it to you, it carries a do not forward. The post office will not forward it. Many don't even know that. They have an arrangement with this. They will not forward an immigration thing. Even though you have gone to post office to put forward my addresses to here, no. If it is not that physical address that you gave them, then that letter is not getting delivered. Sometimes people bring problem to themselves by things that is avoidable. That is my own thinking. And those are the updates for today. Hopefully, those of us who need to act on some of these things, go take some actions on it, because war that is pre-declared does not catch a smart man sleeping at home. It will be up, it will be hustling. When I come back, now we finally take your questions for today. We're coming to it. I know that's what many of you are waiting for, but remember, these questions are individualistic, so to speak. It speaks to somebody's personal question. It may not necessarily appeal to you, even though you have tried to answer these questions in a very broad way, so that even if it is not used personally, that is asking the question, you can learn from it. But I'll see you right after this timeout.
If you're already in the US, you may have a legal pathway to becoming a permanent resident and not even know it. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American immigration dreams without the nightmares. Every week, I meet people who think they're stuck. No papers, no options, no future. But the truth is, they just don't understand the system. Let me give you 3 powerful pathways that people often overlook. Number 1, asylum. If you have a genuine fear of persecution in your home country, you may qualify to stay and eventually get a green card here if you can document it properly with an attorney who knows what he's doing. Number 2, adjustment of status. Some people enter legally and later qualify through marriage, employment, or other categories, but they don't take action on time. Number 3, special protection programs like VAWA, U-Visa, SIJS. These are designed to protect victims and vulnerable individuals. And many people qualify, never apply because they don't even know these options exist. So listen carefully. Immigration law is not always about starting from outside. Sometimes your opportunity is already inside your situation. So before you give up or assume it's over, you may just be one strategy away from fixing your status. So go to speakwithope.com right now, book a consultation appointment, and let's review your case properly. Because in U.S. immigration, what you don't know can cost you everything. Let's talk. Pastors, imams, church workers, there's a U.S. visa specifically designed for you, and many are ignoring it, though they want to come to the U.S. While others are chasing jobs and sponsorships, there's a legal pathway built for people doing genuine religious work who wants to come to America. But because it's not talked about enough, many qualified people never apply. Let me break it down simply for you. There's first the R1 religious worker visa. If you are working as a minister or in a religious role and you have a US-based religious organization willing to sponsor you, then you can live and work in America legally through R1. Secondly, there is the EB4 religious worker green card, and this is where it gets powerful. After qualifying service, you may be able to transition to permanent residency. Now listen carefully. This is not for people looking for shortcuts. You must show genuine religious work, consistent involvement in ministry, and a real organizational structure for your church. The mistake many people make is trying to package it like a business opportunity. No, it's not a business opportunity. Immigration is looking for authenticity, not strategic games. So if you are truly doing the work, you may already qualify for a legal pathway into the U.S. as a minister or as a religious worker. But let's find out. Go to speakwithope.com, book an appointment, and let's review your qualifications for this opportunity. Because when your purpose is clear, your pathway can be too. Just check it out. The Immigrant Survival Show for millions of immigrants. America is not just a country. It is a dream of freedom, opportunity, and a better life. But behind the dream lies a system filled with confusion, fear, and life-changing consequences. One mistake can destroy everything, but the right knowledge can change everything, helping immigrants achieve the American dream without the nightmares. If you are an immigrant in America or you are abroad trying to come to America, you cannot afford to miss this show. Learn how to avoid mistakes that can destroy your case. Discover hidden pathways to adjust and protect your status. Stay ahead of immigration law change and how to prevent your American dream from becoming an American nightmare. Starting now. The Immigrant Survival Show. This is where knowledge becomes power. Okay. All right. Welcome back to Immigrant Survival Show with Ope Banwo and the Four Musketeers. All right. Now we are about to move into the Q&A of the day in the final section of our show for today. Remember, we do this every day as part of our public service for launching our branch office in Dallas, Texas. And after at the end of June, we are going to go to once a week for the Immigrant Survival Show with Ope Banwo. Now we go to the Q&A section of our broadcast tonight. And here is the first question from Grace and Co. Question number one here. How long does it take for the I-485 for an Iranian national to get approved? That's for Hadi, Reston, Virginia. Well, for Hadi, there is no special fixed deadline or timeline for Iranian nationals alone. But many Iranian nationals experience longer processing time due to additional security, I have to be honest with you, and security checks that they are now calling administrative processing or enhanced vetting is what they call it. Let me some water here. For most applicants, the Form I-485, okay, when they are processing it, can range from several months to over 2 years, depending on the immigration category,
the immigration office where this was filed at, the visa availability, the background security checks they have to do. They do that for people from Iran. Where you can imagine that anyway, we're at war with you. The countries are at war with each other, at least until recently. Then also whether a request for evidence was issued. Sometimes when they issue a request for evidence, it basically halts everything concerning that case, and then it gets restarted when you submit. So nationality can sometimes affect the length of security review, but approval is still based on eligibility and admissibility under the immigration law. At least that's what we know, that's what we are saying. So the key point here is Iranian nationality does not automatically prevent approval, but security can sometimes significantly increase the processing times. There's really not much anybody can do about that, and you should know why that is so. Let's go to the second question of the day that we're going to be answering from what you have sent in is Williams from Philadelphia says, how is my citizenship application affected by my spouse if I and my spouse filed for divorce? How is my citizenship application going to be affected if me and my wife decide to file for divorce? Well, Williams, it depends on how you are applying for citizenship in the first place, because there are several ways you can apply for citizenship. Now, if you are applying under the 3-year rule, in other words, if you have been given the permanent resident and because your marriage was already over 2 years before you got your green card, then you'll be applying for citizenship under the 3-year rule based on the marriage to a U.S. citizen, for instance. Then divorcing before that time can significantly affect your eligibility. Remember, to qualify under that 3-year rule for citizenship, you must generally remain married to the person and living with your U.S. citizen spouse up to the time of naturalization, as well as, of course, meeting all the other eligibility requirements. So if you are divorced before that time, so if you divorce before approval, you will usually no longer qualify under the 3-year category, and then you may need to switch to the 5-year general rule as a lawful permanent resident, which is the second type of application where you wait 5 years after your green card. You may have to switch to that if you are divorcing within the 3-year thing. However, if you already qualify under the 5-year rule, a divorce does not automatically stop your citizenship case. But immigration will still review your case for good moral character and past marriage history. So that is why you want to avoid, if you are getting divorced, you want to be exceptionally careful not to get drawn into domestic violence. If your wife also wants to set you up, you can set up a situation of domestic violence. You want to avoid that. It's going to check your past marriage history. So all of that comes into play if you are divorcing before you get it. The key point here is that divorce can remove eligibility for your 3-year citizenship track, if that is where you are on, but not always for the 5-year part. You can still get your citizenship if you are going through the 5-year part, even after you have divorced. I hope that explains for you better. My personal advice is that whatever track you are going on, whether it's a 3-year citizenship thing or the 5-year, the most important thing for you to watch right now when you're getting divorced is that you don't get drawn into a domestic violence situation, because that ruins everything for you. Citizenship you won't get. You might even lose the green card that you have. But it shouldn't affect, bearing that, you should still be able to get your citizenship under the 5-year rule, 5-year option. But if you're applying under the 3-year, then it can affect it, because you are expected to still be married during that 3-year option that you are going for. Let's look at the next question. ON in Washington, D.C. Say, can I fly domestically and connect to Venezuela without being arrested by ICE? Huh. Okay, is that what I just read? Domestically from DC to Miami and then connect to Venezuela. Okay, going outside the country, but you are moving from DC to Miami. Well, many people in different immigration situations, they fly domestically within the US. However, there is no guarantee of safety from immigration enforcement during travel. They still have enforcement actions even for those who are traveling locally or go international. For domestic flights, the TSA, that is the Transport Security Administration, the TSA, they focus on security and identity verification if you are doing domestic flight. So if you don't have any security risk and you have your identity correct, you may not have any problem. However, in certain situations, if there are identity concerns, or maybe you have prior immigration violations, or there are some alerts in government systems, remember they are all connected now, or the Custom and Border Patrol is interested in you, or ICE, then they may become involved. So if a person is undocumented or has immigration issues, your risk increase because identity checks may trigger database flags. I advise my clients who are not properly documented not to fly domestically because they can spot check you and it can trigger database flags. Local law enforcement interaction may lead to ICE notification. Some states notify ICE, especially the non-sanctuary states. So if you're in those areas or are flying through them, you better be careful. I wouldn't. If there's some clauses on my immigration stuff, I'm not going to do that. Some airport enforcement activity is occurring in some locations now. However, there is no official rule. I want to be clear about that. I don't like causing panic because you are misunderstanding me. There is no official rule that ICE must arrest every domestic traveler. And many people, even without papers, have traveled without incident as long as they have their ID card. So the risk depends heavily on your immigration status. If there are some clauses with it, you may not want to travel. Criminal history, that's a definitely no-no. If you have a criminal history and you are undocumented or you are an immigrant, that can be flagged if you happen to be singled out. And from there, you're not going home. They'll take you. That's what they do now. If you have prior removal orders, certainly, I'm not going to encourage you to travel by air because that can get flagged. And if you have been removed before and you came into the country, you know now there's a law that they actually, not only do you get deported, you also serve jail time. If you are removed and you came back again illegally, that's a permanent bar. You can never come back here. So if you are somebody who has been removed before and you came back, you don't want to put yourself where they can single you out. I have been singled out. I'm an American citizen. I've been singled out. In the last maybe about 3 weeks ago, when I wanted to travel for my daughter's graduation, they just took me out of the line. They said that I was flagged by immigration. I'm like, what are they talking about? So they checked me and all that, and they let me go. What I'm saying that could easily have been somebody who didn't have papers. From their problem start, you won't make it home to your daughter's graduation. So I don't know what they are going to Venezuela for, but you want to think about all of these things. Okay, domestic travel is generally allowed. I want to be clear on that. I don't want to use my program and start spreading stupid panic. Domestic travel is generally allowed, but immigration enforcement risk depends on individual immigration history, not the act of flying by itself. But your immigration history is what can give you that risk. Like I've explained, if you have a criminal record somewhere, or your immigration status is shaky, or you have been ordered removed from America before, and or you don't have a proper identity documentation, all of that could then increase your risk significantly. But generally, and I don't want anybody to be scared, there is you can travel. Travel is still allowed. This is still America at the end of the day. I don't think anybody wants to come and get you before your papers are in order. All right, Grace, can we have the fourth question you picked up from the threads? Okay, what do we have here? I applied with my SB1 visa, returning resident visa. It has been 13 months and I've not received my green card. Where can I receive it? Ima, well, an SB1, for those who may not understand what that is, that's a returning resident visa, is used by lawful permanent residents who have stayed outside the country longer than allowed, and then they were approved to the normally, as somebody with a green card, you are not supposed to stay outside the country for more than 6 months at a time. If you're going to come back, you have to get an SB1, that's a returning resident visa, to be able to come. So if you are admitted with an SB1 visa, your green card is not automatically issued immediately at the time of entry. In many cases, immigration must reconfirm your permanent resident status and produce a new card, which can take time. And a delay of 13 months is not normal, I agree. So it may be due to processing backlog, missing fingerprint updates. Maybe you have not gone to update your fingerprint, production delays, or a case transfer between agencies. They may be transferring your file between agencies depending on what they find in there. So here's my advice. You should check your USIS online account for Form I-190. That's what it's called, Form I-90. Form I-90. That's the one that you use to replace green card. Okay, you want to check your online account and submit that if you have not, or follow up notices that they've sent to you. You can also submit an e-request for outside a normal processing time, which it looks like you have entered into now. 13 months is a long time. So you can submit an e-request, what they call e-request, on their website for to check what's going on with your stuff. Or you can contact USCIS directly for your case inquiry. Or you can hire an attorney to help you do the follow-up. For instance, they can follow up officially with a USCIS. They can do the ombudsman intervention. A lot of people are not even aware that immigration has an ombudsman now that you can actually request to help you in a situation like this, for instance, where your case has been delayed for too long. A lot of lawyers don't even know that. You can then go to the ombudsman website. You can then request for them to follow up with immigration for you, and they do. They actually will contact immigration to find out why have they not issued your card, why are they still delaying on your decision, why have they not done what they're supposed to do. And of course, you can also try the congressional assistance, which is for the congressman in your neighborhood. You don't have to know the congressman, because I know some people listen to this say, where will I know congressman? You don't need to know them. You just need to find out the congressman in charge of your area where you live, and then you contact them to intervene in your matter. Of course, you have to follow some procedures. So I encourage you get a lawyer to help you with that, so they can follow up with you on 3 ways: USCIS direct request, even by mail, ombudsman intervention, and then the congressman intervention. So those 3 interventions to help you get your case done, get a decision, or to get your card. And those are very good. Those 3 options are very good if you get a lawyer who knows what he's doing, to be able to pursue a case that has been pending for too long, replacement of your card or card that has been sent. So now you have like 3 different people who are helping you to look into it. So the bottom line here is that the SB1 approval does not always mean automatic or immediate card delivery. It may require additional USCIS processing steps that you may not be taking. That's why you need to talk to a lawyer to look at the whole thing, ask the questions about what you have done, and then explore some of the other stuff that you have not yet explored. I just explained about 3 of them right now. Any reasonably competent lawyer should be able to help you to do that. Or if you want to talk to me on the phone on more specifically, you can book a call and speak with Ope.com, and then we can go from there. Okay, question 5 here. How can my wife contact a congressman or senator to request speeding up the I-130? That's petition for alien relative. That is what Brown said. Yes, this is increasingly becoming an option for many people because immigration is listening to the congressmen and they are listening to other support that is there. Now, Brown, your wife can request for help through a local U.S. congressperson or U.S. senator by submitting what is called a case inquiry, or we also call it congressional inquiry. Okay, they can do that, and they can also do to the USCIS Immigration Services. You can ask your congressman to help you do a congressional inquiry to the USCIS on your matter. And these are some of the steps you can take. You go to the website, the House website. I think it's house.gov/representatives for you to find the representative for your neighborhood. You put your address there. It will tell you who is the congressman that is in charge of your area, even if you've never heard of him. You can do the same thing for Senate by going to senate.gov/senators. That one will tell you the Senate in charge of your area. House.gov/representatives will tell you which one is in charge, which congressman is in charge of your neighborhood. And then you go to their official website. Most of them have a link on their site that is called Help with a Federal Agency. There's a button on most congressmen's website. You click on that button, or some of them will have what is called Immigration Case Assistance. Most of them have this on their website. I'm talking about that representative. So you go to the house.gov or senate.gov/senators or /representatives for the house, get the name of your congressman or the name of the senator representing you, and remember, you don't have to know them personally. This is not Africa. This is not Ghana. This is not South Africa. This is not Nigeria. Okay? People do their jobs here. Once you've gotten their names, you go to their website, their official website, and locate the button for help with the federal agency or help with immigration case assistance. It's always there. Then step 3 is that you complete the privacy release form. This is the form that allows them to officially contact the USCIS on your behalf. So you have to fill that form. They're not going to contact the USCIS unless you complete that privacy release form. Of course, on their side, you're going to provide the receipt number for your case, for that application that you did. You're going to submit a copy of the I-130 or whatever it is that you file. And then I always advise you want to submit proof of urgency. Maybe something like you want to do an affidavit of hardship where you're going to talk about maybe you're going to lose your rent if you don't get this card soon, or you're going to lose your job, or you need it for medical, whatever the urgency is. And of course, if you're working with an attorney, they will help you be able to craft out the ones that are acceptable, or you also can do it yourself. That's what you do. So it's very, very important. I need you to know this. A congressional inquiry does not guarantee faster approval, but it can get you status updates. It can help you flag delays outside of normal processing times. And sometimes it will prompt USCIS to review the file. I don't want you to think of congressional assistance as a magic bullet that all of a sudden will make immigration give you what you want. That's not necessarily true. But immigration at least does listen to them. They will hear from them when they send in the request. So the key point here is that congressional help is for escalation and follow-up, not automatic approval or premium processing. You have to understand that you can't use the back door of a congressional request to bypass the premium processing payment that you're supposed to make or to get automatic approval. They don't work like that. In fact, most Congress people want to know what have you done. They want to see proof that you have also followed up with immigration yourself initially before you do that. So good luck. I hope you can use that to get what you need to do because you wanted to know how you can contact. Just follow those 3 steps and you'll be able to do that. Okay, let's look at the next question that is out there. What is the time frame for a U base 485? Okay, U visa base 485 and 765 adjustment of status. Okay, Johnson. For visa holders, Jolomi, if you are there, can you get me some water, please? For U visa holders, the timeline depends on whether you already have your non-immigrant status approval or a bona fide determination from the US. I'm talking about the USCIS now. That's Immigration Service. So if you have U visa, either it's been approved or you have a bona fide determination for your I-765. Thank you. Sorry about that. I was starting to have a punch. That's to tell I'm getting old. Before I can talk for 10 hours without water. Now I can't talk for more than 2 hours without drinking water. Old age catches up with all of us. So for your work permit, if you have a bona fide determination or you have an approved U visa status, the work permit is normally processed within 3 to 6 months. But with everything these days, delays can extend longer depending on immigration overload or workload. And they've been claiming they have overload for some time now. Thank God for the new hires they just got. Maybe things are going to get better. For the green card, for the I-485, you can only file after 3 years. How this is, I got to take this one. I don't know where my staff is. Good evening, office. Okay, you have a question? Hello? Yeah, good evening. How may I help you? Yes, ma'am. This is Dr. Ope. Yes. Okay. Okay, this is what you need to do because you know I'm live and you call. I thought you had a question that I need to answer live. Okay, so you come to the office tomorrow is fine, but I'm live right now, so they are listening to you. Okay, okay. Sorry, that was somebody who was talking about something about the job, but he's a lawyer. I have to answer it. Where is Jolomi? Jolomi is not picking up her phone. Okay, so as we are still talking about time base for adjustment of status. Okay, so if you're a U visa holder, you can only file for green card after 3 years of continuous physical presence in U visa status. So if you are not yet 3 years in the approved U visa status, then you can't really file for the green card. Now, after you have filed, assuming that you have the 3 years physical presence, it typically, if you look at their side, 12 to 36 months is what they say, depending on background checks, visa availability, and then, of course, immigration workload. So it's all about that these days, okay? So the bottom line here is that your U visa adjustment are generally, they're slow, but they are more stable, and you are protected from removal while this is pending. That is at least a good point here. While they are trying to process your green card, you are protected. That's the whole idea of the U visa in the first place, but it can take a while because they'll tell you the workload is too much right now, and then what can you do? You just have to wait it out. Okay. All right. I hope that is a little bit helpful to you now. Grace, can we have the next question, please? Okay. Can an H-1B specialty worker be a passive minority shareholder in an S Corp? Patel. Huh. Yes, I mean, somebody in H-1B who has H-1B visa Okay, yeah, it can generally be a passive minority shareholder in an S corp because you're not working there, you're just a passive a shareholder. The law allows you that as long as you are not involved in the day-to-day management or making employment decisions. That is very important. The US immigration allows H-1B visa holders to invest in businesses, to own shares, and to receive passive income like dividends, but they cannot actively work for or manage the business without proper authorization. So you have to make sure you stay within that line, or you're going to get into a lot of problem here. However, there's an important corporate law limitation. This is corporate law now. This is not so much about immigration, but about corporate law. S corporations, that is S corps, the rules for S corps, because I have a couple of them, generally require shareholders to be US citizens or lawful permanent residents if they are going to claim on it. Therefore, an H-1B holder is not typically allowed to be an S corp shareholder under the IRS rule. That's my understanding. But of course, I encourage you to talk to a tax lawyer or a corporate attorney better. Okay, but my understanding is that S corp shareholders under the IRS rules, okay, are not allowed to be foreigners, or sorry, to be H-1B holders. H-1B holders are typically not allowed to be shareholders in an S corporation, even if immigration law will allow passive investment. So don't mix the two up. Immigration law allows passive investment, but then there's still the bigger question: does the IRS rules in America allow an H-1B holder to be a shareholder in an S corp? And I will encourage you to research that thoroughly. My off-the-cuff understanding is that it doesn't allow. So the issue is not only immigration law, but also tax and corporate eligibility rules are involved here, and you don't want to violate any of them, because either of them can come and haunt you tomorrow. So my bottom line here is immigration law may allow passive investment, but S corporation ownership, because that's a special type of company, usually disqualify non-resident shareholders. I may be wrong. That is why you should research this further, and you need to talk to corporate attorneys as well as accountants, just to be sure that you're in compliance. Because if you violate IRS rules, that violation can come and haunt your immigration status later. So you want to be very deliberate. You want to be, and by the way, I want to be clear, even though I'm reasonably certain what I just said, I want to be clear that this is just me giving general advice. I'm not giving you specific advice. Before you act on anything I have said, please talk to your lawyer for one-on-one, whether it is me or somebody else, because sometimes general answers may not fit your particular situation. Don't say, oh, I just had the Rottweiler say it, so I'm doing it. Before you implement stuff for yourself, I strongly encourage you, talk to professionals, talk to those who will know better, or talk to an immigration lawyer for one-on-one advice, because every immigration case is different. Consider that my legal disclaimer, because we're allowed to, it's important. This is America. I'm going to flash it. The content of this show is for educational purposes and informational purposes only, and it does not constitute legal advice. Every immigration case is unique. For specific advice to your situation, as you are watching me at home, you need to speak to an immigration lawyer. You need to speak to your lawyer for the specific situation that you find yourself. Very, very important. Okay, that's my disclaimer. Don't come tomorrow and be talking English. All right. Next question here. Let's go here. Let's go. My palm is in the fire for the past 12 months, and I'd like to provide work authorization to spouse on H4 ASAP. Please confirm if there's an option other than the EAD. I'm not sure I'm understanding this mean. Is there any other option other than EAD for your wife to work, or what? Because if your question has to do with just H4, sorry, for most H4 spouses, the main legal work authorization option is H4 EAD, H4 with employment authorization. So under the current immigration rules, an H4 spouse can generally apply for employment authorization. That's the EAD. That's the only option I know. But they can only do it only if, one, the H1B spouse, that is you now, you have an approved I-140. That is the immigrant petition for alien worker. Maybe your employer has filed an I-140 for you for a permanent resident worker, or you, the H1B holder, you have received extensions beyond the 6-year limit under the AC-21. You know what that is? That's the American Competitiveness in the 21st Century Act. They call it AC-21. Okay. If you have received extension beyond the 6-year limit, then your spouse, your H4 spouse, can apply for work permit. Or if you already have an approved I-140, which is permanent, the permanent worker petition, those are the two instances I know. A pending labor certification alone, that is the PAM you are talking about, does not qualify the H4, that is your spouse, for work authorization yet. So you ask for alternatives. I don't know. An alternative may include maybe your spouse independently obtaining another work visa status, like maybe getting her own H1B in her own right if she has a degree and has a company that is filing for her, or maybe an F1 OPT or other status that she can go for in her own right. And there's maybe a couple more that you can discuss with an immigration lawyer about. And if you have the I-140 stage going on, maybe you want to accelerate it if you are eligible to accelerate it. Those are the only options here. Now, of course, discussing our own, being able to apply for H1B in our own right, or doing the F1, the OPT thing, or accelerating your I-140 would depend on specific facts of your case, and they're a little bit involved. It's not something we can discuss online in a few minutes like this. So I would recommend you want to book an appointment with an immigration lawyer, even if it's not me, to talk about possible H1B for your wife, the F1 option, the OPT, and then possibly accelerating your I-140 petition out there. Those are the only things that I can think of that may allow you to be able to put your wife into the EAD position, which is, so those are the 4 options, I think, but you have to discuss them with a competent lawyer so that he can ask you specific questions and depending on the kind of documentation you have. But bottom line of your question is that a pending PAM alone usually does not unlock work authorization for H4. Sorry, but it is what it is. That's the reason they set it like that. And you have to do a little bit more work, talk to a competent lawyer about those 3 or 4 options I just mentioned, and hopefully your wife will be able to qualify into one of them and then maybe get a work permit through that. Okay, we have another question here. Fantastic 4. Okay. We've got something from Arizona, Eric. Can I post on X by tagging USCIS and US Director to ask for an update? This is the age of social media. Even the immigration, they are conversant with social media, what's going on out there. So yes, you can publicly post on X and tag USCIS and US Director, a USCIS Director, but that is not an official or reliable method for getting case updates. I want to be honest with you. Do you know how many thousands can do that? It doesn't mean you can't get that way, because they also monitor these things. Usually, the USCIS does not discuss personal immigration cases publicly due to privacy and security issues. So even if they're going to respond, the party will inbox you, but that's rare. So it will attract attention, I believe. Social media posts may sometimes attract attention, but they rarely replace official case inquiry channels. The immigration is not just a pepper soup thing that you just go out there and just be tagging and then you come and be responding to you publicly. They are not likely to do that. Your better options include checking your USCIS online account, submitting an e-request for delayed cases. They have on their website, they have a button there that you click to do an e-request for your delayed cases. So why do you want to go do tagging on social media for them informally? Also, you can call the USCIS contact center. If you go to their website, you'll be able to get the phone number for their contact center that you can call concerning your case. Or, of course, you also have the option of seeking help through your a U.S. senator or congressperson. That is called the congressional inquiry. I'll talk about that a bit today. Of course, you can also do the ombudsman, the immigration ombudsman. I want to be talking more about that ombudsman because very few people are using them, but they were set up fairly recently to be between the non-immigrant, or to be between the immigrants and the USCIS. And their office is in the office of DHS. So when you send them, they have a procedure, they have a form, I think it's a 7001 or something like that, that you fill on their site, where you put all the information concerning your case. Then they follow it up for you officially with immigration. All those ones help you better than going on social media to be asking for an update. When you have your USCIS online account that you can use to send a request for update, you have the e-request option on their website. That is just a button you click and you fill out some forms, and they will respond to you immediately. They will give you an ID number and all of that stuff. There's a third option. You can call the USCIS contact center. A fourth option, you can go through your congressman or senator for what is called a congressional inquiry. Or number 5, you can actually also go through the ombudsman, the immigration ombudsman, to help you follow your case. Those are much more effective places, okay, for you, options rather, for you. But whatever you do, let me give you this important warning. Never post your full receipt number, your alien number, your passport details, or personal identifying information publicly online. Just take that from me as an advice. You can get yourself into much more problems if scammers get hold of your A number or your receipt number or your passport details, and they do mischief on it. So bottom line, yeah, you may tag USCIS on social media, but official immigration inquiries should still go through the formal USCIS channels. That's one way you can expect a response. Okay? You don't want to go do violence against them on Twitter for what? When you have like 5 or 6 options to actually pursue your case. All right? Hopefully that helps you. Hopefully you calm down a little bit with your aluta that you want to go and do against USCIS on social media. Grace, can you pull up the next question? Okay, question 10 here. I want to petition my 2 parents. You mean you want to petition for them? Rodriguez, okay. I want to petition my 2 parents. They entered the US in 2001 with I-94 and overstayed. Which applications are needed? Okay. First of all, as they say, first of us, as my uncle used to say. Rodriguez, if you're a US citizen and you're at least 21 years old, your parents may still be eligible to adjust status in the US despite the fact that they have overstayed, because parents of US citizens are considered immediate relatives. Since they enter legally with an I-94, the usual filings might be you have to file for each parent separately. Form I-130, which is what they call petition for alien relative, you file a Form I-485, which is application to register permanent resident or to adjust your status. Form I-864, which is an affidavit of support, which is depending on to pledge to support your parents in case they need public support. The government can make you pay for it, blah, blah, blah. Then there's Form I-693, which is the one for medical checkup. And if you want them to get work permit, and that's optional, there are older people who are not going to be working, maybe you don't need that, but you can also apply for employment authorization document for them. That's from I-765. And if they might be traveling while the application is pending, because sometimes this green card petition that you're about to do for them may take a long time. You may also want to file a form I-131. That's the one they call advanced parole document. So if they, since they came in with an I-94, that means they came in legally. You can file papers for them from I-130, since you are asking which applications are needed. About 4 or 5 applications you need. But the most important ones is I-130, petition for alien relative. I-485, that's application to register permanent resident. That's the green card application. Then affidavit of support, I-864. Then number 4, you need the medical examination from I-693. And of course, the ones that are optional, the work permit application, I-765, or from I-131, which is the form for advanced parole, if they need to travel while the application is pending. Of course, in terms of documents to submit, you have to provide proof of your U.S. citizenship, your relationship to each parent. In other words, their names has to be on your birth certificate as your parents. You have to be able to prove that they're your parents, and then you have to have that I-94, even though it has expired, that they made a lawful entry. If they didn't make a lawful entry, then they can adjust their status to green card here. But if they made a lawful entry, then you are good. Even if they didn't, because they are in the immediate relative category, that might still be a way to do that. But before filing, you want to confirm that there are no fraud issues, that they don't have criminal records, that there is no prior deportation removal orders. Many parents, especially those in the southern part of the U.S., many of them come, maybe they get deported and they come back again with coyotes and all that. You want to be sure there's none like that. Okay? Bottom line, yes, a legal entry by your parents with an I-94 often makes adjustment of status possible, even after long overstay for parents of U.S. citizens. If they have that card, even if it has expired, as a parent, they might still be able to figure out a way, they might still be able to adjust filing all those forms that I just mentioned. I hope that answers your question. Again, if you're going to be filing for them, immigration of today is not something you just go out there and just file by yourself just because you could. I always laugh when some tell me we should be just filling forms. Trust me, it's not just filling forms. Sometimes some of those questions are counterintuitive. And if you go and answer it wrong, it can start a whole new problem for your parents for a very long time. Because some question may sound like it's a yes, but when you read it properly, it actually is a no, because of the way it is framed. Sometimes the questions are framed in double negative. So you really need to know what you are doing before you fill some of these forms yourself. But it can be done. I've listed all the forms for you if you really want to do it on yourself. Lots of people do it by themselves, but I personally don't advise it. Right? Let's go. Let's go, let's go, let's go. Okay. That's from Rita. What should I do if my I-94 was stamped only until my passport expiration date, but my I-797 approval notice is valid until October 2027? I can tell you, my man, this is a common issue. Your lawful stay in the U.S. is controlled by the I-94. Is controlled by the expiration date on your I-94, not that longer validity date on your I-797, the approval notice. A lot of people make this mistake. I just talked about it earlier. Once you come into the U.S., what controls the expiration date of your stay here is not the approval notice. In this case, you have it till October 2027. What controls your legal stay is the I-94, the expiration date on it. So if your passport expired earlier, the customs people may have shortened your I-94 to match the expiration date, even though your H-1B remains valid until 2027. You need to understand that. So you need to act before the I-94 expires. It is that I-94 you want to focus on. What time does it expire? So you need to act before it expires. And some of the common solutions will include renewing your passport and then taking your then traveling and re-entering the US to obtain a corrected I-94. In other words, you renew your passport, then you go out before your I-94 expires, and when you're coming back, then you get your corrected I-94. That's one option. Or in some cases, you can file an extension or amendment with the USCIS while you are here for them to put the proper expiration date on your I-94. That is after you have renewed your passport, because I'm not going to put a date that is after the validity of your passport. That makes no sense. Okay, so staying beyond the I-94 expiration can, if you stay beyond the expiration date on your I-94, it can lead to serious unlawful presence, even if the I-797 is still valid. It is important to understand that. A lot of people even argue with me on that until they get into trouble. What controls your valid stay is not the approval date that is on your I-797. It is what is on the I-94 that the CBP issued to you. Remember, they don't even issue it anymore. You have to go to their website to go print it out yourself. It is whatever date that is there that will govern how you can lawfully stay here. And so you want to take action before that expires, or you're going to get in trouble. I'm going to say this one last time on this. The bottom line is the key expiration date that controls you right now is the expiration date on the I-94, not the one on the I-797 expiration date, and that is for everybody. It is important to get that. Okay, let's go. We probably take a few more and then we have to call it a day. I just wanted to make sure we take a few up to 15 questions today. And then if you are not able to take your question today, please, we're just going to roll it over to the next broadcast if there is time. Typically, we take those who are posting live or those who are calling in live. We take their questions first, and then we try to accommodate as much as possible. Okay. Next question here says, how do I request a refund of my USCIS premium processing? KK from Texas. You know that when government has collected your money, they don't want to give you back now. It's every government. Whether it's Nigeria, whether it's Ghana, America is not different. But, my man, you can request or receive a refund of your of the premium fees that you pay to immigration only in very limited situations. Typically or generally, immigration will refund the premium processing fee if, one, the immigration failed to take qualifying action within the required premium processing time frame, or the service was mistakenly accepted for a case that was not eligible. In other words, if your case is not eligible on the face of it, but they accepted it anyway before they then rejected it, you can request for a refund of your premium processing fee. Or if they didn't process your stuff within the required time, like let's say 21 days or 14 days or 30 days that they're supposed to respond based on premium processing, you can request your. As a matter of fact, there's a lot of people in the employment-based categories who file. I'm talking about EB2, I'm talking about H1B, and other who file with premium processing, and their case is supposed to be answered within 15 working days, but some of them have not been resolved within 3 months, 4 months. They are still holding and they don't have an RFE. Normally, when there's an RFE, that is a request for evidence, it stops the clock. And until you respond to that request for evidence, the clock of the 15 working days does not restart. But these people said they never got any request for evidence, but immigration did not make a decision on the time frame for premium processing. And many of them are not even thinking about going to go get their money. And at one point, I was toying with the idea of doing a class action, because there's thousands of them literally. And those is a lot of money. Some of those premium processing are 2,500, some of them are 3,000, some of them, there's a lot of money. So if they don't give you premium processing service, you should be entitled to your money, and it's in their rules on those two conditions where they did not take the qualifying action within the required premium processing time frame. So you can request your refund. Usually, immigration will automatically issue the refund if they miss the processing deadline. I've seen one or two where they refunded, but generally they don't. So you may contact USCIS if you believe a refund was overlooked. Sometimes they just overlook some, and that is where you can contact them. You can even use congressional help at that point. You can use ombudsman. Ombudsman is probably your best bet here to get your money back if they did not take a qualifying action. If you qualify under one of those two categories of people who can get their money back, that is, they did not take action within the required premium processing time frame, or the case was mistakenly accepted by them, even though the case was not eligible, and they simply then told you it's not eligible later, then they have to pay you your money back. But be assured, immigration will not just refund the fee simply because they denied your petition. You are not going to get your feedback on that. Or because they delayed, because it was delayed for request for evidence. As long as they issue you a request for evidence, then the time is told. So they're not going to give you a refund because when they issue you your RFE, they're telling you to respond in 120 days past the premium processing time. You're not going to get a refund for that. Or if you just change your mind, you have filed, you have submitted, and then you change your mind that you don't want to do premium processing again, you want a refund of your money, they're not going to give you your money back that way. It's not in the rules. But you can contact the Immigration Contact Center or the premium processing unit handling your case in terms of trying to get your refund if you believe that you are eligible. Bottom line, premium processing refunds are mainly available when USCIS, that's immigration, misses its guaranteed processing deadline. If they miss their guaranteed processing deadline, just like when you do a next day delivery and you made the payment to post office, if they don't deliver next day, then you get your money back. So same way with USCIS, but you have to apply for it. And if they're not giving it to you, then you can then seek ombudsman support. You apply to the ombudsman or you apply to the congressman to make a request of them to find out why they're not giving you your money back. And those are generally effective in getting your money. All right? Don't be afraid. If you are owed your money, go get it. They don't keep. This is still America, you know. I know that immigrant might say, "Who wants to go and ask immigration for money?" They come and deport me. They don't do like that here. They don't they are not vindictive like that. At least that's what I think. I don't know if that is changed. All right. One more question before we go on break here. Mr. Rao. Can I apply for H4 dependent visa if my wife has an active F1, okay, but has not traveled to the US yet? I'm not sure I understand what, but if it is as you stated it here, that can you apply for H4 for your wife? That means you have an H1B. If your wife, or if you don't have H1B, I don't know how you want to apply for H4 for your wife. So, no. An H4 dependent visa is only available for spouses of H1B holders, not F1. Okay? Okay, so if you have an H1B visa, yes, you can apply for H4 for your wife. But if you are not, then you can't. If your wife if you are yourself, if what you have is an F1, but this one I think you said is your wife that has S1, so that have S1, so F1. Whether you can apply for H4 for her depends on whether you have an H1B yourself. If your wife currently has only an F1 visa, you generally cannot apply for H4 for her based on that status. Instead, you yourself may qualify for an F2 dependent of an F1 visa holder because you are a spouse. It's not just for women. Men that are also spouses of students get to apply for F2 also. However, for an F2 visa application, the U.S. Embassy may want to see that the F1 student genuinely intends to begin studies, our record on service is active, and the school program that she got is legitimate. So there's a lot of stuff they look at. Okay, so your wife does not always need to be the one to enter the U.S. first, of course. Officers may allow you, but they will closely look at the whole thing. But for your question directly, where you are saying, can you apply for H4 for your wife if she has an F1? The question doesn't correlate. The H4 is a dependent visa for somebody who has H1B. So you have to have an active H1B before you can apply for H4 for her, but you have not, your question didn't clarify that, but I'm assuming that. Okay, so if that is true, now assuming that you do have an H1B, yes, you can apply for H4 for your wife because it's totally different from the F1 student thing that she already has. It's basically like she's changing her status even before she comes in. So that's the best I can answer for that, because you didn't give one key ingredient, whether you yourself are in H1B or not. Okay. All right. For those of you just watching us from home, you are live with Ope Banwo, and you are watching the Immigrant Survivor Show with Ope Banwo, America's no-nonsense immigrant talk survivor show, with the four musketeers. They carry their musket. They're like, Daddy, let's go. It is late. We're already over 2 hours on this. I want to appreciate you guys for coming in today, but we'll take a couple more questions when we come back, because we missed yesterday's show. So let's give you a bonus today. Right after this time out, there's some questions already answered on video. Hopefully that will address some of the situation that you are going through. And when we come back, we will take a few more questions before we call it a day.
If you're a creator, musician, or influencer, you may already qualify for a US visa and you don't even know it. Most creatives think immigration to US is only for doctors, engineers, or people with job offers. That's not true. There's an entire visa category built for people with talent, visibility, and influence. Let me break it down for you. First, there is the O1 visa. This is for individuals with extraordinary ability. And listen, you don't need a Grammy or an Oscar to qualify for this. If you have been featured, if you have performed, if you have been recognized, if you have built a strong following, or worked on notable projects, you may already have the foundation to get this visa. Secondly, there is the P visa. This is for performers and groups, artists, entertainers, and athletes, especially if you travel or perform internationally. And here is what most people miss. Your Instagram, your YouTube, your media features, your collaborations, those are not just content. They are immigration evidence. The problem is, most creatives don't document their success properly. So they look ordinary on paper when in reality, they are far from it. So if you are talented and getting attention, you may be sitting on a visa opportunity right now for yourself and members of your family. So go to speakwithope.com, book an appointment, and let's turn your talent into a legal pathway into America. Because in today's world, your influence can open immigration doors for you. And I can help you with that. Book that appointment now and let's talk. If you are trying to live and work in the US based on your skills, education, or professional experience, let me be direct. Your success or failure often comes down to one thing: how well your case is structured from the very beginning. Because immigration is not impressed by your potential, They respond to properly positioned evidence only. I have seen highly qualified professionals, engineers, executives, doctors, founders get denied, not because they were not good enough, but because they chose the wrong visa category. The documentation was weak, or their petition lacked a clear legal strategy. And once a case is filed the wrong way, fixing it later becomes much, much harder. Now, here's the hard part most people don't understand. There isn't just one path to immigration in the US. Depending on your background, you may qualify for EB1 for extraordinary ability people, EB2 national impact people, EB3 skilled professionals, H1B specialty occupations, O1 exceptional talent, and many more like that. But choosing the right path and presenting it clearly and correctly, that's what you need. At Banwo Law, we don't just file applications. We build strategic immigration cases. We evaluate your profile, identify the strongest pathways, and structure your petition based on how immigration actually reviews cases. From documentation to legal positioning to long-term approval strategy, everything is done with one goal in mind: approval. So if you're a professional with specialized skills, a business executive or manager, a techie or healthcare professional, an entrepreneur or founder, or someone with some exceptional ability, then this is exactly where you need to be. If you're serious about building your future in the US, don't leave your case to guesswork, online advice, or trial and error. Call us now at 888-215-5054 or schedule a consultation with me on speakwithope.com to get clear, strategic path forward. Because when it comes to employment-based immigration, the right strategy doesn't just improve your chances, it defines them and gets it ready for approval. My name is Dr. Ope Banwo, and I'm the founder of Banwo Law. We represent professionals nationwide across the United States.
Banwo Law and Eisen proudly present the USA Immigrant Hall of Fame, celebrating remarkable immigrants who came to America, overcame adversity, achieved greatness, and helped shape the greatest nation on earth. Their journey, their sacrifice, their legacy. Banwo Law and Eisen proudly present.
Thank you so much. That's all we can do for tonight. We appreciate you for being on the call tonight. Thank you so much, Samuel. Thank you, Grace, for making this show a successful one tonight. I look forward to seeing you all tomorrow. And thank you guys at home. Remember, strategy beats emotion any day. Wake up, think about where you are right now in your immigration journey, and seek help before immigration knocks on your door. I will see you tomorrow. Stay safe. Good night.